Hi there, I'm James Dapperty, and this is Coffee and a Case Note. Guys, today we're talking about an easement for a water pipe, right? The owner of the dominant tenement, the owner of the beneficiary of the easement, is an irrigation company and needs to pump water. The owner of the servient tenement, which is the owner of the property that has the pipe running through it, wants to develop the property so they can put in place some backpacker accommodation. And plan A for the backpacker accommodation involves a driveway being constructed over the top of this pipe. Forgive me. And what is initially contemplated is that some agreement might be reached between the parties. As the matter progresses, the plaintiff, which is to say the owner of the irrigation pipe and the beneficiary of the easement, gets a little bit worried because it has an expert's report suggesting that the pipe is going to be damaged by these construction works. And so what it does is, among other things, it approaches the defendant, it approaches the would-be backpacker hostel developer to say, look, could you please agree not to undertake any construction works because we're worried about this pipe getting damaged. Get it? So this request is made and it essentially takes the form of a demand. Do not cause the construction works to take place because there may be this damage arising from it. There's no reply to that letter. Time passes. The plaintiff sends someone out to the property to take some photographs. Those photographs suggest that there might be work going on that could damage the pipe, and what the plaintiff then does is go and then seek urgent interlocutory relief, goes and seeks an injunction. So this is on the 18th of December 2018, last year. The injunction is granted, and the injunction is granted with the consent of the defendant. The defendant sort of says, or gives undertakings in the same form as the injunction to say, yeah, agreed, we won't do any of these works in the way that the plaintiff, the irrigator, is complaining of. Forgive me. The matter continues. The defendant, a backpacker hostel developer, lodges a different DA that would actually protect the pipeline, and essentially we all end up holding hands and very happy with each other. The only outstanding question is who pays the irrigator, the water pipe owner's legal costs. Because the water pipe owner says, well, hey, we all ended up agreeing on this plan. We went and commenced proceedings, so you should have to pay our legal costs. Now, the plaintiff had to confront UCPR Rule 42.19, which essentially says that if proceedings are discontinued, which is what those proceedings were because of that agreement, then each party bears their own costs. Now, what the plaintiff then had to do is say, no, this is a different example. And it's different because, firstly, we had no choice but to go seek this injunction because it looked to us for all money that the defendant was about to build this driveway and ruin our pipe. So we had no choice but to go to court. Second thing they say is, based on everything the defendant had available to it to make the decision, it was unreasonable for it not to agree to the demand and not to respond in time. And then thirdly, what the plaintiff says is, look, in any case, even though it was discontinued, basically we got what we want, so we were successful. And so the plaintiff makes these three arguments. The court has to consider them closely, including the responses of the defendant, who obviously doesn't accept these things and really engages with Rule 42.19 in an attempt to firm up its position. But what the court eventually finds is that despite the usual position being set out with 42.19, here it was unreasonable for the defendant not to respond to that demand. You remember our pipeline owner made that demand for there to be no construction works. And so what the court found was that the defendant, our backpacker hostel developer, had to pay the costs of our irrigator pipe owner. The defendant had to pay the plaintiff. And I hope that quick jaunt down to sunny Griffith and some water irrigation and backpacker hostel adventures was of assistance to you. And I look forward to joining you again soon for another coffee and another case note. Cheers.